Working.
No good?
No, it's working.
Okay.
We're live streaming.
Okay.
The radical, fundamental principles of freedom, rational self-interest, and individual rights. This is the Yaron Brook Show.
All right, everybody. Welcome to Yaron Brook Show on this Saturday, May 10th. Hope everybody's having a good beginning to the weekend. I'm really happy today to have Larry Salzman on with me. I mean, there's so much going on when it comes to legal issues, judiciary, the Supreme Court. It's like every day there's something new. So it's great to talk to somebody who is an expert in the field and who is involved in one of the cases. So we'll talk about that as well. Hi, Larry.
Hi. Good morning, Yaron.
So Larry is with Pacific Legal Foundation, and that's defense property rights and defense basically the Constitution, and regularly sues the government. You guys have had some major successes over the last few years. Maybe say a little bit about PLF and give people the context. I know you've been on before, but there's always new listeners. It'll be great to do that.
Yeah, absolutely. Well, Larry Salzman, I'm the Vice President for Litigation, Policy, and Research at PLF. PLF is a public interest law firm, which is to say that we are ideological. We have an idea about changing the law. Our role here is to secure enduring legal change in the direction of freedom. And we sort of focus our resources, at least in recent years and for the foreseeable future, in property rights, separation of powers, and equality and opportunity related issues. And just to give some of scope, we've got 55 litigating attorneys. I've got about 10 or 12 additional attorneys that either are working in legislatures, sort of dovetailing with the litigators. Sometimes we can't achieve something in court, or you achieve something in court, and in order to make it entrench it or make it go broader or extend it to other states, you work with people on model bills in state legislatures or even in Congress to do that. And then we have a small team of people who are essentially scholars who are writing articles, organizing workshops, trying to reach elite legal audiences with the ideas that we have, the theories that we have, the legal objectives that we have. It's kind of softening elite legal culture so that when our cases come up and take a little more radical position, it's not people scratching their head and wondering if it's crazy. It's like, no, there's a body of research around this. There's a body of scholarship around this. And in some sense, we try to mainstream some of our more radical ideas in that way. So I run that legal department, set the strategy for the organization. And as you indicated, over the years, we've had 20 cases before the United States Supreme Court. We've won 18 of them. And I can talk about any of those or sort of what we're doing for next year and how that's going. But that's kind of the scale of it. We have 175 cases actively being litigated sort of as of this morning, as we're sitting here simultaneously in courts across the country. That's across maybe 35, 36 states.
Wow.
So we're almost everywhere. And when it comes to property and economic freedom and equality before the law and separation of powers, we're pretty much suing everyone in every direction. So we're involved in a lot of those cases. And that's what PLF does.
That's great. So, there's a particular case I think you filed a couple of weeks ago on the tariffs,
Yeah.
Trump tariffs, and there've been, I think, there are 5 or 6 of these cases now.
I think there may be 6 now. Yeah.
6. So tell us a little bit about your lawsuit, maybe how it is different from the others, and what is the basis, really, what unites all these lawsuits in terms of the tariff issue.
Yeah, we represent half a dozen or so clients. The lead client is a gaming company or toy company, board game company called Princess, or a clothing company rather, and a board game company, Stonemaier Games, and Princess Awesome. So the case is actually styled Princess Awesome versus the government. So
That's great.
yeah, it's just got a good name in that sense. And look, they're people who are importers, right? They're board game people, they're toy manufacturers. It's a company that manufactures and builds mosaic tile projects. Somebody who maybe is known to a lot of your listeners, the Cordair Gallery, who has a gallery in Montana. They're one of the clients because they import art from overseas.
Yep.
And so our clients in these cases are all people who are affected by the most recent raft of tariffs that the president established. And The case itself is relatively simple, but deep and fundamental. It's that the president is claiming this unilateral authority to impose tariffs everywhere and anywhere, sort of at will, against countries, and he's claiming that authority under a statute called the International Emergency Economic Powers Act. And we look at that act and we come to a few conclusions. One, it doesn't have anything about tariffs in it. So I don't think he's exercising any lawful authority under the statute. So what he's doing is unlawful at the very least in that regard. To the extent that one could make an argument about that. Now, the law looks like what it was aimed after. I think the legislative history is clear, is imposing embargoes and trade sanctions on, say, nations that are doing something harmful, and the president may need rapid response to say, hey, you're doing this, you got to stop, or I'm going to punish you with a trade sanction, or you got to stop importing a particular product. So it allows him to regulate trade, but it doesn't allow him to tax trade. And so on the one hand, it's just violating the statute. And so the authority's claim doesn't exist in our view under the statute. The second point is, to the extent you can make an argument, well, maybe the word regulate is very expansive and maybe it could include a tariff. All those powers to use that statute get unlocked when an emergency is occurring. And there's a pretty tight understanding of what an emergency is in the statute. At least that's our view. It hasn't really been adjudicated extensively. That's one of the problems here. The president's just using authority because courts haven't spoken much to the statute in the past. But our view is this isn't an emergency. Like, he's talking about a trade deficit that had been accumulating for decades and decades and decades. Even if you could, buy into the trade theory that he has, it's not an emergency. It's a very slowly accreting problem. It's the opposite of an emergency, and you could wind your way out of that problem if Congress wanted to by changing trade policy in various ways. So there's not an emergency. So he really can't use the emergency declaration he's using, whether it's the deficit one, or on the other hand, he's saying China and Mexico and Canada are letting drugs into the country or selling precursors to fentanyl, things like that. None of those things, in our view, meet the definition of the emergency of the statute. So again, he's claiming power in the statute that the statute just doesn't give him. So it's either misreading the statute or using the wrong statute. And even if courts were inclined to go his direction on those things, I say, President Trump's direction on those things, we look at the statute and we think it's pretty open-ended. Like, even if he was in a real emergency, and even if it did allow tariffs, the language that has been delegated to the president to impose trade sanctions, if it were trade sanctions, is so open-ended. Our view is that the Congress is actually delegating legislative power to the president of the United States. And that itself is power that Congress can't give away. And so the statute itself is unconstitutional in that sense. And so it's sort of this multi-headed argument of he doesn't have the power of the statute. If the statute authorizes it, he's exceeding that power. And we don't think the statute can authorize it because it exceeds Congress's ability to delegate its own authority to the president of the United States. I think that's, you asked a little bit, so some of these cases, how are they different? A lot of them have overlapping claims. There are some cases that are brought by states, and in a sense, their claims are a little different. They're saying you're harming us. They're sort of federalism claims. You're sort of harming us to harming our states, you're harming our tax revenue. In some cases, they are also saying, and also you don't have this power under the statute. So there's some overlap there. A couple of cases out there, including one, I don't know if you had Ilya Soman on or not.
Not yet, but yeah, I've seen that case, yeah.
Yeah, so he's working very closely in that case with people at Liberty Justice Center, which is another good public interest law firm, filed a case. Their case is very much like ours. I think there's a couple of differences. One, I think it's beneficial to have multiple cases going on, even in the same court, but certainly at different courts like NCLA, the New Civil Liberties Alliance. They have a case in Florida.
Okay.
And there are people just trying different litigation strategies to see what will stick and what will make it through the courts. And I think it's beneficial in public interest litigation to have some diversity of cases. You don't want to have 20 redundant cases, but if you have plausible reasons to say, well, a court might do this, it might do that, hitting it from different angles helps. And so NCLA, for instance, has an idea that we want to be in Florida. We want to be before a U.S. district court because we think the main argument is that this whole statute is unconstitutional and it doesn't authorize any tariffs. And we want a regular district court to say that. We went into the Court of International Trade, which has all the powers of a U.S. district court, but it also has exclusive jurisdiction over cases involving tariffs. And so our view is, well, if a judge is inclined to think that maybe this authorizes tariffs, but there's questions or it's unconstitutional, we should be there so we don't get dismissed and kicked out. And I know like NCLA is fighting about that, whether they have to get moved to a different court now. And
Okay.
we'll see where this goes. Liberty Justice Center, which again has overlapping claims with us, and they're doing good work.
Yep.
They filed a preliminary injunction. Our view was we don't want to do that, and maybe it helps to have one case going for that and one case not going for that, because if you seek a preliminary injunction, what you're looking for is the judge to rule very early on your case and say, hey, this is harming us so much that it's irreparable. Our view is if the damages are money, judges are unlikely to say it's irreparable. At some point, they can ultimately remedy the problem with award of damages if that's the case.
Yeah.
And so we decided not to do that, because what happens if you get a preliminary injunction or you lose it and you go up and appeal, the standard of review is a little different and it's a little more deferential toward the government. And so we thought, well, we can actually just work fast, get a final judgment on, say, a motion for summary judgment that's a final judgment that's appealable to appellate courts in a way that is not particularly deferential to the government. So, they'll do it their way, we'll do it our way. And what you ultimately want to get, if you want to get to the United States Supreme Court, sometimes is having different courts disagree. And so, because then it becomes more compelling to the Supreme Court to say, we got to jump in this now, because now we've got a real problem with the judiciary. So if we end up, in some sense, we win or we lose, and NCLA wins and we lose in the lower courts, you almost want to be in different courts of appeal to have different courts thinking about this. And it sort of creates a funnel into the Supreme Court that's a little faster.
So I think I read that your case is up in front of the court pretty soon. I mean, next week.
No, that's actually the Liberty Justice Center. Yeah, because they did the preliminary injunction, they get fast tracked a little bit. It is true. I can break a little news because I don't think it's going to change, and it doesn't really matter. But we're filing a motion for summary judgment as soon as next week, so we're moving very fast.
Okay.
Yeah.
So where is their case going to be heard?
Theirs is before a 3-judge panel at the Court of International Trade. So
Also,
Liberty Center and I are both in the same court at this point.
Okay.
Yeah.
Okay.
I mean, we may get different judges, but we're both in the same court.
Yeah. Interesting.
Yeah.
So.
And it's very friendly. I know Ilya, we know the people at the Justice Center, vice versa. So, we've talked a little bit about that, and you never know where it goes. Like, we could be on different timelines. They might be on appeal in a different court by the time we're getting a final judgment at the Court of International Trade, because they're moving for this early judgment and we're moving for a more normal judgment. So that might go that way. It could be that we end up on the same track and we get consolidated and we're basically all of us now combined in one single case, which wouldn't be the end of the world either. We just have more heads around the table thinking about how to do it well. Yep.
And I mean, I assume you took the case because you believe it's winnable. I mean, what's your sense of how the Supreme Court would look at this?
Yeah, that's I do think it's winnable. Maybe that's a good pivot in some sense to what I think is kind of going on at the court. The court over the last decade is very interested in separation of powers issues. So I would say, the last time they struck down or avoided a statute for delegating legislative power to the executive in an unconstitutional way was 1934. So on the one hand, you would say, oh, this is, what are you guys trying to do? But over the last 10 years, they've dropped comment after comment after comment in cases involving the separation of powers to the effect that, hey, there's something wrong here. We're going to have to address it at some point. And so there's a lot of cases going up that are just trying to get to this issue of whether legislative power can be delegated to the executive in an expansive way. And, here we have something that's affecting the entire economy. It's a pretty radical and not that plausible position that the administration is taking about the meaning of the statute. And to us, that's a good vehicle for the Supreme Court, where they say, yeah, on the one hand, they might be loath to strike down a signature policy of a political party. On the other hand, if that party is way out on a limb on their interpretation of the statute and it's affecting the entire economy in a way that it looks like Congress would have never intended, that also gives it an easy path for the Supreme Court to say, actually, this is exactly where we have to step in. So we think it's winnable just because the idea of the delegation is more plausible in this case than others, but also it's winnable because the just plain text of the statute just doesn't allow tariffs. And so it could also be an easy way for the Supreme Court to, or appellate court here, to just slap it away and say, we're not going to get to that constitutional issue in this case. We don't have to. You administration feel lucky we don't have to, because you've taken such a radical position on this statute that it's not a plausible position. And of course, they come in with the opposite view. They're completely confident about everything they're trying to do, but it just doesn't pass muster. If you look at the threshold for what is required to declare an emergency, and then the fact that nowhere in the statute is the word tariff appear,
Yep.
and the whole legislative history is replete not only with, it's about trade sanctions or restrictions on imports as opposed to taxes, but the history of the statute, the IEPA, International Emergency Economic Powers, or International Emergency Power. I just lost it. It's too easy.
That's fine.
Anyway, there is, but the point is, one thing that Congress was trying to do with the statute when it was enacted is that Nixon used a predecessor statute to impose a tariff, and Congress didn't like it. And they said, well, we have to clarify the fact that the president just can't impose tariffs in this way automatically or unilaterally. So they passed this statute to remedy that. And then the president now is saying, well, that's the statute that gives me the power to do the exact thing that you tried to enact this statute to stop Nixon from doing. It doesn't make any sense.
No, and this relates to the 10% tariff across the board.
It's the 10% tariff across the board, but he's claiming that it's the same statute that's claiming authority to do both the 10% tariff across the board and also all of these reciprocal tariffs that you've seen the chart of.
What about
China?
The reciprocal, and then what about the industry specific ones like the auto and the steel tariffs?
Yeah, some of those tariffs might be attackable on the 10% thing, but we did not bring a claim on what's called Section 232 of a different statute that's being invoked, or the Trading with the Enemies Act. We didn't bring claims against any of those, so we're not going to touch the steel.
Okay.
I think it's steel and aluminum are the ones we were trying to avoid, because there is a previous decision from decades ago that probably wouldn't pass muster today, but it did say a tariff is plausible or is allowable under those statutes. So we're like, well, we don't want to just walk into a precedent problem where the problem here is this brand new claimed authority for these unilateral reciprocal tariffs everywhere. Let's just go after that, and we can deal with the other problem once we get that settled.
Yeah, I mean, it seems like the steel and aluminum one, most presidents have embraced it in one way or another and used that Section 132 or whatever it is, national security or whatever, on that. Although I think he's the first one to use it for autos.
Yeah.
National security.
Yeah. So I think I don't know, where to go in this conversation. I'm happy to talk about some of the other things that the administration is doing. Part of my job, I have my views. I'm an objectivist. I have my sort of moral and political views. I try to talk about the things that are in the law because I find the environment interesting. And part of what without trying to sound too generous to President Trump or the administration, a lot of the conversations I get into lately are trying to look at, well, what is the claimed authority? What are they actually doing? What is the status of these cases? Because there's a lot of talk about, well, we're rushing toward authoritarianism. I'm worried about a lot of things he's doing. I'm particularly worried with the tone and the attitude that he's doing them. But, I think what's more interesting is just looking at what the administration is doing and what the claimed legal authority is and what the sort of status of that is. Because there's a lot of nuance involved sometimes, and there's a lot of alarm. And so some things he's doing are very plainly unconstitutional. And some things he's doing are radical and norm-breaking and causing confusion, I think, among courts and causing debates in Congress, but probably are on more sound legal footing, despite the fact that they're quite radical. And I think that's also why the political environment is so fractured on the administration, is that people who might be alarmed at some of what he's doing are also looking and saying, yeah, but no president in my lifetime would do these other things that seem sound and that I like. And so what do I do about that? I think that's why people are so confounded in some sense. You get this administration is a little bit chaotic in that there are some people around him who I don't think they know what they're doing. And I think they're stepping into problems and they're making claims that don't have any basis. And then there are a lot of other people around him that if you look behind the scenes at some of these executive orders and what's going on with them, like, oh, there are very sophisticated legal minds that are developing a strategy here, and they're making moves that may seem whimsical because of the way the president talks about them, but in fact have a fairly sophisticated legal strategy underneath them. and are trying to do something to uproot the administrative state that has accreted in the United States since the 1930s.
Give us an example of those, because as we know, the court is quite favorable towards uprooting the administrative state. So there's actually real opportunities, I
Yeah.
think. So what examples of executive orders that he's done that are moving us in that direction?
Yeah, so he did an executive order recently that something along the lines of conforming agency regulations to Supreme Court precedent. So on the one hand, you hear all this like we want to impeach judges we don't like. It's
Yeah.
kind of wild talk around him. And on the other hand, you have an executive order that's coming out that says, I'm interested in hearing the Supreme Court precedent, and the Supreme Court has issued a lot of decisions affecting the validity of administrative regulations. I'm directing these specific agencies, almost all the agencies, but a dozen or so that he names, to say, here's 10 Supreme Court precedents in the last 5-7 years that I want you to look carefully at, because I think a lot of the rules that were promulgated over the past few decades do not comply with Supreme Court precedent. And it's vital and urgent for you to uproot those things and abandon them and narrow your jurisdiction. And so you have, on the one hand, a fear that the president is sort of grabbing all this administrative power and using it to ends that we might not like. And on the other hand, in that executive order, or another one involving the Clean Water Act and another involving the Endangered Species Act that I saw recently, some that are about unleashing energy production and reconsidering how public lands are available for natural resource extraction and multiple use, what they call multiple use, not just conservation, but
Yep.
for productive enterprise. All of these things, in fact, if you look at those executive orders, with a caveat that I can talk about, that some of them invoke some kind of emergencies and national security, and that's kind of interesting, and I can explain what I think is going on there. But most of these things are saying, we actually want to shrink executive power. I'm commanding you, the agencies, to look in your house and conform better to the statutes that Congress has enacted, conform to what the Supreme Court has said. And I want you to abandon jurisdiction that you think you have had over the last 30, 50 years to regulate this, to regulate that, and let people do what they will in terms of economic freedom, or at least let things happen according to the statute. So you have these two different factors, on the immigration stuff, for instance, is just pushing, or on the tariff stuff, they're pushing these kind of wild readings of statutes, and we'll see what happens in the courts with all of that. And on the other hand, you have a pretty studied attempt to roll back the administrative state by giving up executive power and telling executive agencies, you think you've had this power all this time, but that's not actually the power that Congress granted us. You need to shrink in various ways. You need to regulate less in various ways. You need to reinterpret rules to be more in conformance with the grants of power given to you by Congress, and to make sure that you don't supersede the boundaries that have been established by the Supreme Court in various precedents. So it's a
Almost like this.
chaotic environment where you look at it and you see, but I think there is a kind of deliberate mind there. And I don't know if this is a good analogy or not, but it occurred to me maybe, I don't know, a few weeks into the administration, and I was like, how alarmed do I need to be? Like, what do we need to, what's our priorities? For PLF, the priorities are the things we're after: separation of powers and property rights.
Sure.
So there are just a lot of things that we let go. We just don't pay attention to as an organization, because it's like, well, unless it is within our mission, we could do everything and do anything, and we probably wouldn't get anything done. There are a lot of organizations, FIRE, Foundation for Individual Rights and Expression, does great work around free speech. They're defending and they're suing him on various things. And you look at the ACLU is suing him. I mean, they made like $500 million in the first Trump administration, raised just to be the resistance, essentially. And they filed, 100 cases already or something just in the first 100 days. So, so there's a lot of people out there attacking various pieces. So I focus on what I'm focused on.
Yeah.
And I try to keep my head down and be disciplined to get what we can while this administration is here, and not get sort of distracted by the things that might just disappear when this administration is gone, so to speak. Because a lot of these EOs, executive orders, will disappear. But the analogy I kind of used when I got into a few weeks in is, 10, 15 years ago, if you were in Silicon Valley, everybody wanted to be the Uber of everything. the way to raise money was like, well, I'm the Uber for pet food or whatever.
Yeah,
It
yeah.
got more and more ridiculous. And I think what we're seeing in some sense with the people who came in around him are like, well, we're going to be the Uber for the presidency. And I mean that in a certain sense. And it reminded me as I started watching him doing what he's doing, a conversation I had with Travis Kalanick, who is the CEO of Uber,
Yeah.
was founded. This was in 2011, 2012. So right 6 months after they were founded. They were in like 3 cities. And they came into Washington, D.C., and Washington, D.C. tried to regulate them out of existence. And somehow I got in touch with Kalanick, and he was willing to take a meeting with me. And I said, look, I think what the D.C. is doing is unconstitutional. I think there are various ways to attack this. And we could get some precedent that would sort of open up the legal atmosphere so that Uber could just flourish and not be having to fight tickets and play
Mhm.
cat and mouse with the regulators in every city they went into. And so we had this conversation about that. And he asked very good questions. He's very sharp.
Once, yeah.
And at the end of the conversation, I just thought, oh, okay, he's really intrigued, and I'm never going to hear from this guy again. And I'm never going to hear from him again because what I heard during the call was, that's all great. I'm really excited. I'm sort of even with you on the political stuff, where you're sort of going with the law.
Yeah.
But I've got a burn rate that means that I've got to be in 15 cities in the next 6 to 12 months.
Well, it's time for the courts. Yeah.
I'm not going to be able to get through a motion for summary judgment in one city if this is our strategy. So I'm going to have to do what I'm going to do. And what he did was, sort of the story of Uber, which was they just went into cities. It was illegal almost everywhere, was violating all the taxi cab laws. They were operating in a total guerrilla fashion, and they wouldn't announce that they were in a city for 6 weeks after they were in a city. And then they'd kind of go public with it. But what was happening at that point was you would have millions of people had this app on their phone. So by the time they got announced, they had such a large number of riders that when the city started ticking them and clamping down, they would just go to the city council and they would have the room filled with Uber riders saying, no, you need to change the law to let Uber in. And so in some sense, they just hijacked the political process by going in, moving fast, showing the results of their efforts, and then they developed the political support. This president's policies are not Uber,
No.
but I think that's what they essentially had in mind. And so what you have going on, and the reason why so many of these executive orders have got some kind of trigger in them for national security, or sometimes they claim inherent Article 2 powers. Article 2 powers, that Article 2 is the portion of the Constitution that defines the core powers of the presidency. They're changing, with the Doge stuff, they're firing all the people, they're canceling all the contracts, they're moving people, whether it's to, out of the country or to El Salvador, or the most recent thing, they're removing the parole status for 500,000 people. They're doing it all quickly, and they're doing it by linking it to sort of national security or foreign affairs powers or other core presidential powers, or in some cases, statutes that have not been interpreted in a long time and are very broad and expansive, because what that does is give them 6 months of cover to not get immediately stopped by the courts, or Congress has got to step back and actually pass a law to stop them from doing it. And so, I think that's the way in which they're thinking about this. They're just rushing, claiming things that are kind of hard for courts to get their hands around. And the hope, I think, among the earnest of them is, well, look, if we get 2 years into this and we successfully deregulate the energy industry, if we successfully increase the capacity to use land use, if we start showing people you're mining and making it better in certain ways, people are going to support this. The reason I don't think they're Uber is at the same time they're doing some of these things I think are beneficial, they're also doing things that are going to blow up in their face and are backfiring and that people are really angry about. And so they might not be able to sustain it. They're going to get hit by the Supreme Court at some point, maybe the tariff case, maybe something else, and it may disrupt their plans. But that's why I think you see a lot of these executive orders. It's, the sinister way of looking at it is, oh, he's an authoritarian and he's just trying to aggrandize power. Maybe. But I think it's also very explainable by the fact that he's got really smart lawyers around him. They're thinking about how do we actually get this done? And they're trying to cope with the fact that the context here is 90 years of a growing administrative state. And there is a kind of a reality. If you come into office and you even have big deregulatory plans or big plans to change policy, even if it's not deregulation, even if it's just, I want to pivot from one administration to the other to get tough on immigration, say, or whatever it is, there's actually no way to do it by conventional legal means within the space of a single presidency. So you can't get it done. And this is part of the story of why, whether it's Republican or Democrats, the administrative state grows and it grows and it grows. Part of it is that they all have similar ideas and they're bad ideas, but some of it is just you can't overcome the bureaucracy. The bureaucracy is so entrenched. So
But is it
that's
the
why he's,
bureaucracy, or is it the fact that we have such a incompetent Congress, that is a Congress that doesn't actually take on any controversial issues,
yeah,
won't, because Congress could do the immigration stuff. Everything that he wants could be passed by law if he had the votes for it. Right?
yeah, absolutely. And just, but what so I think part of
Because if we
MAGA,
think
or at least
back, if
part
we
of the
think
people
back
that,
to Jimmy Carter, who started the deregulation, everything passed through Congress,
Mhm.
right? They deregulated trucking and airlines, and every one of those was a bill that went through Congress, and they could do it back then. And today, it's just impossible to do anything in Congress.
it feels impossible. I mean,
Feels that way anyway.
that's the right thing. So I mean, that's the difference between, say, he's doing a lot of radical things. It's probably not more radical than anything FDR did in one sense, but what FDR had was a legislative program, and he got it all done through legislation. It's
Mhm.
also why it lasted for 75 years.
Yep.
And so I think that the people around him who are not necessarily signed on to the MAGA agenda, but see this as a kind of moment or an opportunity, and the people who are designing a legal strategy behind it are more on the premise of like, yeah, we would love to do that. We think that Congress should be acting. We've gone for, maybe 30, 40 years of saying that it's not happening.
Yep.
What can we do? And this is what they've come up with. They just, let's move quickly. Let's see if we can prove out some results. In order to do that, we have to do things that are way against norms, and we got to tack into statutes that are going to be confounding to the courts for a little bit to give us a year or 2 years runway before we're shut down. And whether that works or not, I don't know. I'm skeptical as somebody who has a theory of history that ideas are what move
Yep.
it, that you can sort of trick your way into a good result that way. But there is a kind of political science problem here of like, well, we've created this administrative state. It doesn't really fit within the confines of the Constitution,
Mhm.
and yet we've had decade after decade after decade where why doesn't Congress act? Well, you have Congress in the 1930s and maybe beyond doing things that were way exceeding its enumerated powers, and the courts essentially acquiescing.
Yep.
And so that was a problem. But in the course of that, you built an administrative state, and Congress found it, I think, very positive in terms of its ability to maintain power, or at least the ease of maintaining power or raising money, to sort of disclaim accountability for a lot of the policies. So more and more gets delegated to the administrative agencies. And those people are completely impossible to, Congress can't fire them. The president really can't fire them. This
Yep.
president is trying in some new ways. But that's the point. This president is saying, well, that's the problem, is you can't make the bureaucracy turn on a dime unless I start doing things like firing half of them.
Yep.
And everybody says, well, wait a second, you got all these civil service laws. And he's saying, that's fine, but all these civil service laws and the norms that were created over the past 60 or 70 years are all just administrative interpretations of those laws. I'm going to take the maximum view of those laws and let the courts tell me I'm wrong.
Mhm.
Everybody's freaking out, but he's saying, yeah, but you live by the administrative, you die by it. All these norms were created by administrative regulation, and I'm just setting it aside, saying I'm the president and they should follow what I want to do. And so you have a lot of chaos, but again, it's his way of seeing, can I get ahead of the political cycle in some sense?
Yep.
I don't know how much of that Trump has, but it's just
Somebody
clear to
does
me
in
if
the
you start
background.
reading enough of the papers they're filing in court and the executive orders, that the reasons for why they do things, even things like as venal in my view as it is, like the El Salvador thing, like
Yeah.
why is he, why that? Like why not just house people in jails and stage them here? As cruel as that might be, you could do that. Or why not put them in Guantanamo? And they had to pick a place that was totally outside of the U.S. jurisdiction in order to get around previous Supreme Court precedent that said people are entitled to habeas corpus and other sort of protections if they're in Guantanamo Bay. So it's not an accident that they found some,
Hmm.
you know, authoritarian pest hole in South America or Latin America
Yeah.
to put them in, because because the courts don't know what to do with that, and they need to do something new in order to do with that, and that buys them 6 months, 12 months, 18 months.
Are
Uh,
you worried by the fact that they seem to be ignoring the courts with regard to bringing this guy back?
yeah, I'm worried about a lot of yeah, well, yeah, the Abrego Garcia thing. I
Yep.
mean, uh, yeah, and there's just a human side of that where I
Yeah.
just think it's incredibly cruel.
Yeah.
Uh,
The whole
but
sending these people to El Salvador is unbelievably cool.
yeah, but am I worried about? So yeah, I'm worried about some of the tone and some of the language, but there's a lot of different, when like he'll say, the president of the United States will say, look, I'm going to comply with court orders. I'm not going to violate court orders. Now, some of the people around him are pretty loose about that, and it's really, he should be firing them, right? And the fact that he's not is worrying. On the end, if you look at what they're actually doing, um, they're pushing boundaries a little bit. But when the Supreme Court came back the second time and said, you're not going to use the Alien Enemies Act to deport anybody else like that, they haven't deported a single other person.
Mhm.
And uh, the
Well,
fact they haven't gotten that guy back, even though they said facilitate, I think that's a problem. Um, on the other hand, if I set aside the humane piece of it, and I just think, well, as a legal matter, this case is churning through the court still, right? So he's resting on a pretty absurd idea of what facilitation means or what it should mean. He's getting himself into trouble probably by saying things like, well, I could get him out if I wanted to, the other day. That's going to backfire on him when it gets to court again. But remember, it went up to the Supreme Court the first and the second time in this very rapid emergency posture. Now it's actually in the lower courts and it's making its way through the Court of Appeals. When it gets back to the Supreme Court, it's going to be in a more ordinary posture. They'll have a real oral argument. They're going to be able to press the attorneys on this. They're going to come out with a reasoned decision. So, uh, yeah, it concerns me, the tone, but I also see that there's a process here, and I do have a lot of confidence in that process, because what I see going on, broad strokes, even stepping back from the current administration and what's been going on for a decade or more from the Supreme Court is, you know, I made my peace with it, I guess, in that I don't think this court is particularly concerned about individual rights. That's not what animates them. What animates the majority of this court at this point is separation of powers, and they do have a fairly deep theory about that. I think they care about liberty. It's not that they don't care about individual rights, but they have a perspective of the country. The Constitution was broken in some sense by the administrative state. They recognize that. There's also kind of reliance interest and all kinds of things. They don't want the rule of law to change too quickly, so there's a lot of factors in their mind, I'm sure. But what they really seem to care about is getting back to that place where Congress does take responsibility for enacting laws. So they're not going to come in and say, um, they're not as interested in saying these people have this due process right or this right to free speech. They will say that if they're pressed, and the cases will get to them eventually. But what they're more interested in saying is, hey, uh, you're acting beyond the authority that Congress gave you. And to the extent that he's acting in some of these areas with authority that Congress gave him that's too expansive, that we would judge as irresponsible from an individual rights perspective, the Supreme Court really wants to sit back and say, we just want to say that, and then give Congress an opportunity to then go fix the law. And at some point, I think they're hoping the Supreme Court has the idea that uh, if we say that enough times over and over, that, hey, this is Congress's fault, this is Congress's responsibility, that will animate an electorate to throw people out who don't respect individual rights. And it's a very indirect way of protecting individual rights, but it's the theory of the judiciary that the current Supreme Court has, that they think that's their role. It's not to go fix all the problems that Congress won't fix. It's to insist that when the president is acting in ways that the public think are cruel or wrong, if he's doing it with congressional authority and it's not, strictly speaking, unconstitutional, they're just going to say that and put the onus back on Congress to go fix that problem.
How do you think they're going to interpret this Aliens Enemies Act? I mean, it
Yeah,
seems a little bit like the tariff thing, and it's declaring an emergency
yeah.
invasion where there is none. And I guess it's only been used during war. So
Yeah.
Do you think there's enough room there for them to say no, this is within his powers?
I think it is tough. I mean, this is why when I say it's very studied what I think they're doing in the, whatever, whoever's designing the legal strategies.
Yeah.
And, I've read some of the things in the Wall Street Journal that sometimes the lawyers get, they're just political people in the State Department or whatever who are ignoring what the lawyers are saying. So, there's also mistakes that can be made on both sides of that. But it's a little studied because if you just ask me, I mean, Article 2 does give the power to negotiate with foreign leaders to the president of the United States, and it's pretty exclusive. It's a core power. These are the kinds of questions that came up in the immunity decision, or the so-called immunity decision that came up a year or two ago. What's core and what review does the court actually have on things that the Congress or that the Constitution ascribes to the president pretty exclusively or wholly exclusively. So I think if you said like, could they say, go get this person back or go negotiate with the president of El Salvador and demand that he come back? I don't think a court can say that. And I think that there are going to be certain things where if the president presses and Congress doesn't act, Congress can always take those powers away pretty easily. They have all kinds of levers and checks and balances to stop him from doing things that are wild. But courts at some point may have to say, look, we can complain about it. We can say what we think is wrong about it, but we actually have no power to command the president to do certain things. I think they have a lot of levers in that particular circumstance, though. I mean, first of all, the whole context, there's kind of a ruse here, right? I mean, we created the danger that these people are in. And there is a doctrine under the due process clause over the years. It's not one the courts like to invoke, and they don't invoke it rarely, but a so-called state-created danger doctrine. So this comes up in the context often of people probably know, like on the one hand, you think as a normal person that the job of the police is to protect you and protect your individual rights in some sense. But when the rubber meets the road and they fail in some sense, and you go to court to say, hey, you didn't protect me, and my husband died, or my kid got killed, or I was assaulted, you'll lose those cases. And you'll lose those cases because the courts have said, actually, you don't have an individual right to police protection. And yeah, that may be their job in a political sense, but your vote is what assures that in some sense. Like we can't, as the court, tell the police how to protect you in certain circumstances. So there's this idea of, do you have a due process right not to be neglected by the authorities?
Yep.
And probably not. But an exception to that is what's so-called state-created danger doctrine. The courts have said, yeah, but let's look at what's really happening. If the police put you in peril in some sense, they absolutely have a duty at that point to protect you, or they'll face liability. And I think you can make that kind of argument here, that it's one thing to say, if I was on vacation in China and I got arrested and it was all a mistake and I was being held there against my will, and maybe it was even because of the government's policies, that the China was retaliating against me as an arbitrary measure, the courts really couldn't tell the president of the United States, go fix that problem, go negotiate to get a hostage back.
Yeah.
I don't think they can.
Yeah.
I don't think the Article 3 gives them that power. I think Article 2 really lets the president decide what's in the best interest of the United States in terms of how I negotiate with foreign leaders. On the other hand, if they sent me there and they told Chinese authorities to arrest me, they've created the danger. I think it's a different circumstance. Now, practically, what can they do? I don't know. I think they could issue a judgment on that basis, and they'd have to hope at that point Congress would have their backs to do everything possible to enforce that.
Yeah.
Yeah.
And just the broad use of the AEA for the whole immigration program that they're doing right now.
Yeah. I mean, I think that's what it's actually pretty limited. So they're a lot of what they're doing in immigration is being done under the Immigration Naturalization Act, and they're just taking different interpretations of that act. And some of them, to my view, may be plausible, even if I think they're not decent in a moral sense. But
I mean, AEA, I think they've defined these two gangs as national security threats, and therefore we can send them to prisons overseas or to Libya.
Right. So I think that's the other thing the courts can do. And in some sense, bad facts make bad law. Bad administrative actions maybe create incentives for the court to do things that otherwise wouldn't do. in this case, well, what I think courts probably can do is say, okay, fine, we can't force you to negotiate with foreign leaders, but we are going to claim authority as the courts to decide what that word invasion means.
Yep.
And if you're exceeding it,
Okay.
we're going to declare it and we expect you to stop. And
Yep.
I think that's legitimate. What the president will say is that gets a little too close to my ability to, manage
Foreign
wars.
policy.
And I think that's why I say, bad facts make bad laws. I think if that got to the Supreme Court today, the Supreme Court would probably say, actually, no, we're going to stand on our right to interpret that statute, and you don't have authority to do that.
Hmm.
If it were another president who was acting in a little closer call, if it was President Bush
Yeah.
acting in the face of the Iraqi war, saying, I'm going to round up people who have recently arrived from Libya or something because I don't know what's going on. Like they probably would have given a pass, and I don't think they're going to give this president a pass in that sense.
Yeah. So the court is going to make a decision, I think, this coming week over this idea of whether district federal judges can, can put a national-wide injunction, or whether it only applies to their district. Is this important, and what's your view on this?
Yeah, I think it's important. It's again kind of nuanced. It really bothers me a lot. It concerns me long term, just in terms of the political trends, that the way this is being described is like rogue judges, and there is some group of politicians have like a Rogue Judges Act or something. That whole framing strikes me as wrong because, in my view, the story of the 20th century was a relentless and unconstitutional aggrandizement of power by the executive and the legislative branches,
Yep.
and the judiciary largely acquiescing. And so if we're going after any branch and trying to strengthen the principles of limited government, I'm least concerned about the judges. So that's the context that I come to it with.
Mm-hmm.
Now, the nuance is there's something here and there's something here that's been bouncing around for 40 years. And again, it's sort of like it's come to a head now because Trump is doing things that other presidents weren't doing. And so it's creating kind of chaos and atmosphere. And it's like, oh, there's these problems running around that we haven't solved in a long time. We better address them now. And so what is the problem? It's judges under the Constitution have the power to decide cases and controversies. And that typically means between the parties before them. And for most of our history, you'd go into court and you get a judgment, and they would say, some tax statute was applied against you and your own, and you paid a tax and you claimed that it wasn't legitimate, and you got a refund, and you got a refund. That didn't mean necessarily everyone in the world who wasn't a part of that case would benefit from your judgment. If you go to an injunction, it's a little bit interesting, where if you're suing the federal government, what do you do if, like, I'm being deported or I'm being treated in a certain way under the Immigration and Naturalization Act as a single person? I'm a party before the court, and the court says, actually, the whole interpretation of the statute is wrong. So yeah, you have to let your own go. But then what else? Like, does that mean, and now the agency can't do the same thing to anyone else?
Yeah.
That's what they mean by sort of nationwide injunction. Like, does it apply to the people beyond the parties? And I think until just a couple decades ago, the answer was clearer that no, it only applied to the parties before the courts. And the Article 3 has a long history, from England forward, of what do courts do. And they decide discrete, concrete cases and controversies. They don't decide large political issues that involve everybody who's a non-party before the court. So the reason why it's become an issue is it wasn't until maybe 30 years ago where you started getting lower court judges who would say, you're enjoined from enforcing this law against the party in front of me and also anyone else in the country. And it was invoked, that kind of power, an injunction like that. You'd see it, every 6 months, there'd be one judge. It would get stuff worked out on appeal. Wasn't a big deal. Started accelerating a little more during the Obama administration, maybe a little bit during the Bush administration before that. More of these things by conservatives suing the Biden administration. It went crazy during the first Trump administration because every single thing he did was a lawsuit. Everything he did was a lawsuit. And a lot of lower court judges, because he was breaking a lot of norms, were like, I don't know what to do with this exactly, but I'm just going to enjoin it, until we get the full adjudication resolved. And it ties up the administration.
Mm-hmm.
And now in the second administration, It's again, literally everything he's doing to the point where it's something like 100 or more, I think I read, injunctions of his actions by lower court judges that apply nationwide. So at that point, you may think, well, that may be something to celebrate because you don't like any of what he's doing. But if you're the administration and you're thinking about this a little more broadly about like, well, how do we run an executive branch? It starts to feel like there's something off here if everything it's trying to do gets blocked by one of the 2,000 lower court judges in the country, right? It seems like you can't do anything at that point because everything will be sued, everything will be enjoined. And so the Supreme Court has taken this case up in the context of the birthright citizenship case. I don't think they're going to touch on the merits of that question at all yet. That this case has a long time to run.
Yep.
What is actually up under is, well, our policy was enjoined by a lower court nationwide. What's the scope of the judge's power? And I think there's a reasonable argument that the judges are exceeding their Article 3 authority, and they need some guidance from the Supreme Court to explain in what circumstances, if any, an injunction beyond the parties is plausible. Certainly, it's correct in class actions, and so maybe you'll see a lot more class actions. That's still not, quote, nationwide. That's just whatever the class is, but it could be a very large class. And then I think there's a separate question that gets ignored by some of the conservatives arguing about this, or some of the people complaining about rogue judges, which is Congress, in the 1950s, 1940s, gave district court judges authority under the Administrative Procedures Act to, quote, set aside actions of an administrative agency. And almost by its nature, those would be nationwide. So if you sue an administrative agency for doing something, if you say I'm a bank and they're collecting information from my customers, and I think it's a violation of privacy or Fourth Amendment, or come up in the immigration context or in the economic context, you just go and you say, well, this agency, Health and Human Services or Department of Interior or Commerce, they have a law or a regulation based on a law that they're enforcing. We think this regulation is invalid under the statute, and we want you to review it under the Administrative Procedures Act. The remedy is to set aside that interpretation of the law or set aside that class of actions. So by its nature, since you're setting it aside at the agency level, that agency operates nationwide, so the ruling would be nationwide. Yep. So, I'm also not worried about the sky falling. Like, yeah, it's not that judges are not going to have the power to restrain the federal government if some of this power from the judges is clawed back to have nationwide injunctions. Certain types of cases, certain issues will be harder to get those kind of nationwide effect through a lower court judgment, but so be it. I mean, you can get a more narrow injunction. It gets appealed. An appellate court speaks with a broader scope. It goes to the Supreme Court. It ultimately becomes nationwide. So in some senses, it's about process more than what the ultimate effect may be.
So like birthright citizenship, if a district court puts an injunction on it and it's not nationwide,
right?
I mean, what does that mean?
Yeah, it's a problem. Like what it means is that the person who brought the lawsuit is not going to be subject to removal. But if the administration is arresting 100 people around them on the next day, they all have to bring their own cases.
Yeah. So it's
or they have to figure out a class action to do it.
Okay. So in order to stop it, everybody would, so you'd have to have a class action. Everybody, in a sense, who was, I mean, is the issue here that they're not issuing citizenship to babies born right now in the United States if their parents are not?
I think that's it. Yeah, I think that's what they're doing. Yeah.
So
they've issued I think they've issued some kind of executive order, or they've passed some regulation at the whatever agencies control this. I don't even know, maybe it's Health and Human Services, to not allow the printing of birth certificates or passports with citizenship if the two parents were not citizens or not legal residents. I think green card holders, they're accepting those people. Yeah. So it's a mess. And I'm just going to sound too conservative, I guess, but I've become more. Earlier in my career, I would have been like, yeah, I love nationwide injunctions. Everything should be stopped immediately all the time. But because it sounds inefficient to do it any other way, or it sounds like you're allowing injustice to go forward either way. But practically, this is the way lawsuits go on by private parties all the time. They're not, non-parties are not bound by judgments. And it's just not the case. You get a couple of judgments and the world changes. And the same would be true of this. It's not like you're going to get an administration who's like over and over and over going to be forum shopping to find a district in which this injunction doesn't apply and do the same wrong thing, because each time it comes up, the case gets resolved against it faster and faster and with greater prejudice, and sometimes then with sanctions. And you know, you have a little room to work the policy out or get to the appellate courts, but at some point, you know, you take down a buffalo.
Yeah.
Indians on the plains would take down a buffalo by shooting a lot of arrows into it. At some point, enough arrows come and the buffalo goes down, and so it's a little bit less efficient. On the other hand, you don't have this oddity where maybe you do have a president or a law that's enacted with a majority of the Democratic electorate, and yet any one of the thousands of judges could halt it on a dime. Something doesn't quite feel right about that either, long term.
What's your time constraint?
I'm okay. I'm okay at least for another half hour.
Okay, because I've got the questions accumulating here, and I've
got we can answer questions. And you talked about the tariff thing that PLF is doing. I might as well put in a plug for something else that TLF is doing. We have these areas: property rights, separation of powers, equality and opportunity. We are making a pretty hard push over this next year and growing a whole new program practice area around environment and natural resources. And I think that's, sometimes I know you've had Alex Epstein on and talk about him a lot. And it's sort of in that vein. We just look that this is probably the right moment. If this court is serious about separation of powers, some of what's going on around the, nationalism that's going on, our view is like we're classical liberal in our perspective at PLF. That's essentially our footprint ideologically. And yet we're looking for coalitions if we're going to get things done. And you look at the left is talking about abundance as something that's important to them. You're talking about the right that's talking about, well, we want to reindustrialize in some sense. As classical liberals, I think, well, I don't want to be out of the debate, but what can we bring to the debate? And some of it is, look, nationalists, if you really want to build things in America, you got to eliminate the thicket that makes it impossible to build anything, the regulatory thicket. And if you're the left talking about how we can't get anything done anymore, or you got $2 million public bathrooms in Berkeley or whatever inspired Ezra Klein's book, you have to change that. And the way to change that is just sue in every direction around the environmental laws and around the laws that prohibit serious extraction and development of natural resources in America, whether it's rare earth minerals or uranium, or even if it's just fishing, or offshore drilling. There are all kinds of small innovators, entrepreneurs that are the kinds of clients that a public interest organization like ours should be taking on to say, if you would just eliminate this regulation, or if you could see that this law isn't within the enumerated powers, we could have a lot better things. In many sense, our prosperity or the lack of it here is just a choice. It's a policy choice. And a lot of these policies in our view are unconstitutional. So we're doing a lot more work over the next couple of years you're going to see in the natural resources space.
Good. And I think you're right. The timing's right. I think people are eager for this.
I want to have, you can ask me a question, but I say something about Doge. I want to say something about Doge too. But again, you got to watch the theme of like, I'm going to sound like I like everything this administration is doing, but you're hard on Doge. I think you're spot on with that. The money that they claim to be saving, they're not saving money. They're doing a lot of things that are just weird, like all this like canceling contracts. There's a process for canceling contracts. Like this is all going to blow up on them in court cases. On the other hand, there's a kind of hidden structure to Doge that I don't. It's not hidden. It's in the executive orders, and especially the executive order that established Doge. But I think it's easy to miss because they're not talking about that hidden structure much, or there's no reason to talk about it. What they're doing is all this flashy stuff about saving you money that's not likely to save anything. But what's actually happening with Doge? They've got some sort of central hub of people who I think are pretty sophisticated legal minds, and they're on the task of, they put it as making government more efficient. I don't think these people are, they're not, some of the people I've met don't appear to me to be particularly MAGA or particularly libertarian. They're more like the Supreme Court in the sense of like, well, we're just trying to break the administrative state to make the political system operate with more accountability as it was established by Madison. And we're just trying things. And so what have they actually done? They have this hub of people that probably are operating in, the executive office of the president or something but then they've sent out all these spokes, small teams into every agency. And from what I can tell, what's going on is Trump is appointing people. Some of are, really good from even, your political, my political perspective, like Department of Interior and the people who are running energy, Secretary of Energy, things like some of these people are very good. But what I'm hearing, and the reason why DOJ is built this way, is those teams going into those agencies from DOJ are not the people who are saying cut everything. Well, in some cases they're saying cut personnel, but they're more taking a hard look at the regulations, and there's a sort of interaction between the heads of these agencies and the very small DOJ teams that are mostly lawyers, I think, who are saying, let us show you, head of the agency, what the enabling statutes are. Let us show you the thicket of regulations that purport to rely on those things. And then let us tell you what we think you're on really solid ground in ignoring or reversing all those regulations. And what I'm hearing, a little chatter that I get is even the best of these agency heads, they get in and they're like, it's me and the 10 people I brought in with me. And there are literally hundreds or thousands of employees. We have no idea whether what they're doing is, good legally or not. We don't really have an ability to force them to do this versus that. So you, the DOJ team, have got to help me tell me what regulation is to rescind. And I don't think you'd have that without DOJ. I think you'd have a lot of pretty helpless and overwhelmed agency heads, even the better of them, without a kind of red team, essentially, that goes in from DOJ to say, yeah, let's get serious about this. These are all the things you have to cut. We've been talking about this for 40 years, maybe the Bush administration or maybe the Reagan administration wanted to do some of these things. It didn't realize that there was this thicket of regulation that was sustaining the administrative state and the bureaucracy. Unless you eliminate it, you're not going to get anywhere. Whether they'll be successful at that, I'm not sure, but that's why you see the huge volume of executive orders coming out that are just, they're killing rafts of regulation. And that's mostly coming from DOJ, in my opinion.
Yeah. So it's interesting because, the way DOJ is presented is it's a bunch of programmers, not a bunch of lawyers.
That's right.
And maybe Elon Musk leaving is going to do a lot of good.
Yeah. Or it might start focusing the attention on the lawyers, which probably wouldn't be good in terms of them being effective. But we'll see.
Maybe.
Yeah.
Yeah. I mean, I was just reading today that, that mine that I guess they were using for pensions.
Yeah.
Where everything was by hand, that a team of programmers have already basically automated all that. And
Awesome.
Ultimately the mines are going to go out of service because it took them, 2 months, and they've already created online a automated system to do that. You hear about that. You don't think in terms of DOJ lawyers, teams of lawyers, as a thing. So, I mean, that's great. If that's what they're doing, then that's terrific.
I don't know. I don't have enough insight or enough connection with the administration to know exactly what these teams look like. But if you look at the executive orders, they're small teams. They're sending in like 3 or 4 people to each agency. And I think the executive order actually says like one of them has to be a lawyer.
Okay.
And I think they're struggling to find lawyers. Like they're happy about that to some degree. Like there's just hemorrhaging lawyers from the Civil Rights Division of the Department of Justice, for instance. And it's because the lawyers are just quitting because they don't want to do the work that they're being asked to do under the new leadership. And I think the leadership is saying, well, that's great. And we do need lawyers, but those are not the lawyers we wanted because they were going to be resisting everything we're trying to do. Some of which I think we would agree with quite a lot, in enforcing a colorblind view of the 14th Amendment, things like that. But I think they're having a hard time backfilling. Just there's not enough lawyers that they can hire. But the lawyers that I've seen who are in DOJ, these are people who are very serious lawyers coming out of, mid-level people coming out of big firms where they're doing really good work, or, they're all federal appellate clerks and Supreme Court clerks. They're pretty good people that I've bumped into.
I mean, I hear there's a rift between Trump and the Federalist Society. Do you think that's going to affect the people he nominates and the people he brings in?
I don't know. Maybe. And I don't know what that rift is. Like I heard an interview recently with Leonard Leo, who was, involved there and was architect in some sense of what they did during the first administration. And it does sound from his from his telling that just Trump isn't going to talk to him and isn't going to let him influence anything. So maybe that's true. On the other hand, um, I think it's chaotic, right? If you get the people who, if Stephen Miller is helping him pick judges, right, he's going to get, or Josh Hawley or somebody, he's going to get one group of people. On the
Well,
other
I
hand, he's
was
got a
like,
lot of people around him who are not that, they're
yeah,
former
yeah,
uh, Justice Thomas clerks or former Chief Justice Roberts clerks, and they know what is true, and they know what a good judge looks like. Whether he'll take their counsel, I don't know, but he's got to rely on somebody to give him counsel, and I
yeah.
think that there are still a lot of those voices around the table.
Yeah, my concern was it just because I was reading a description of a few federal nominees that he's
Yeah,
just appointment, and the first one on the list was a Josh Hawley guy, so it's
yeah.
somebody who'd been I guess legal counsel to Josh Hawley. So
I mean, again, this is part
hard.
of the theme of Congress get it in gear, right? I mean, that's the check.
Yeah,
Like they don't have to confirm
there
these
is,
people.
but we know there's no check there. I mean, all you have to do is look at Health and Human Services, and you can see
Yeah,
there's literally no check. I mean,
yeah, yeah. I mean that's a long story too, and I know we're trying to get to questions, but
yeah,
they all point fingers. The right says, well, we wouldn't have gotten rid of the filibuster for judicial nominations to make it so easy to get people in if you hadn't done what you did
yep,
with Judge Bork, if you wouldn't have done what Mitch McConnell did to hold out for to get rid of Merrick Garland, and
hmm,
and the left says, well, now we're never going to let you get back a filibuster because we're going to make sure we have the same power when we get in. So it's a real mess in terms
it's a
of the
mess.
political dysfunction.
It's a mess. Now they didn't need there was no, was there a filibuster proof majority for other government appointees or just for judges?
Uh, I don't know, actually. I think at one time it could have been invoked for anybody, but over the
Okay.
years
Okay.
it gets complicated. I have people on my team who know these rules
Yeah. Yeah.
exceptionally well, but there are cloture processes and some things that require 60 senators and some require now 51. And it's all been sliding around based on the politics. It's all been one
Yeah.
administration after
Exactly.
another since Reagan, basically, of recrimination. They keep weakening the checks
Hmm.
in order to gain some advantage cycle to cycle. And
Yeah.
yeah,
Right. Let's do some questions and we'll see
please.
see what's left. Okay. Michael asks, how soon will the Supreme Court hear the tariffs case? Is it likely these tariffs will be ruled unconstitutional as early as this fall?
Um, I don't think it'll happen as early as this fall. So the the best circumstance would be some one of these preliminary injunction cases. So either the one that Liberty Justice Center filed, or I think some of the state cases have filed a preliminary injunction. Those could get decided very rapidly by the trial courts, within the next 30 days, and then it'll go pretty quickly to an appeal. They'll get an expedited treatment on appeal, and you could maybe get a decision turned around in 3 or 4 months. But even if the Supreme Court then took it, they would set it up for an argument, and my guess it would be winter, something like that. And the likelihood is it's even further off, 12 months or more. If it's our case, for instance, that goes up, it's probably going to take a couple of months for it to get through the trial court, then 6 more months to get through the appellate court, and you're probably talking about next spring, even if the Supreme Court decided to take it. So yeah, things don't quite move that fast.
Uh,
On the other hand, you could get a situation where a trial court uh, would actually rule for these plaintiffs and enjoin the tariffs,
yep.
and then the tariffs are gone until the Supreme Court holds. So that would be the best circumstance for the plaintiffs, but is just a kind of speculating. But I think it's unlikely any of the trial courts are going to rule for the plaintiffs. I think they're going to say
Really?
this is such a or if they do, the appellate courts might put that injunction on hold
Hmm.
because it's such a signature policy of the president, and it's
Yeah.
such an uncharted territory. My gut is that the lower courts are going to say we don't want to go out on a limb if we think it might be a stretch, but still a close constitutional question. They're going to want to wait.
For the Supreme Court. Yeah. Interesting.
Yeah. I hope I'm wrong about that. And
Yeah, me too, but I think you're probably right. Um, Ian says, how did the stonemasonries games get involved with your tariff lawsuit? In general, he says the board game industry seems to be very threatened by current China tariffs.
yeah, I mean, I think that's exactly why, when we started talking to people about the fact that had some clients, we were interested in adding more clients. We originally had like a pet food company, and it was a little of an issue because they imported a lot from Canada, and it wasn't clear that there might be alternative authority for the president to impose tariffs on Canada. So we're like, well, we want more clients. So we just started talking to a wider circle of people.
Yep.
And very quickly, somebody from the board game industry approached us and said, actually, like, you could have 5 dozen people tomorrow if you wanted to represent the toy and board game industry, because they just import everything from China. And I don't know what I read yesterday something like 83% of all of our toys are coming from China in America, or maybe it's all toys under a certain dollar threshold, and 97% of our fireworks. So there's certain industries where it's like basically you just call up anybody at random who's in that industry, and they're almost certainly threatened with serious economic peril.
Yeah, I saw an interview with Mattel's CEO, and he was saying, look, all our toys are designed in the United States, engineered in the United States, designed, but we're not going to make them. And if we don't make them in China, we'll make them somewhere else, but we're not going to make them in the United States. Nobody will be able to afford them if they can't, if we do.
Yeah.
So it's
yeah, I mean, there are all the economic arguments about the
Yeah.
tariffs, and
Yeah.
What I've been just more focused on is the legal thing. It's just
Sure.
like, well,
Sure.
whatever the economic issues of the trade policy, you can't do it.
Yeah.
That's the legal issue.
Yeah. Is the fact that one of the big tariffs on China, does that complicate things in any way? The perception, at least, of China being a national security issue versus the 10% on everybody, which is clearly absurd to think of it as national security.
I don't think his argument about national security is plausible. I mean, so I don't really think it'll affect it. On the other hand, we did look for a range of clients that were importing from a lot of countries just for that reason, just so that it wasn't China versus the United States at some point. It was like, so some of our board game companies, for instance, are China, but we have people importing things from Italy and Peru and Turkey and England. And, so in part, we wanted to have people who were friendly nations so that if it really got to the Supreme Court would say, wait a second, you're invoking an emergency power to impose a tariff on somebody you have most favored nation trade status with, or, like the whole thing seems like a rationalization at that point.
Good. All right, Jennifer, she said, I read the lab meat manufacturers are suing Florida for banning lab meat. How can a state get away with banning an FDA-approved federally legal product? Do you think they will? Do you think they'll win?
Well, there's some different cases there that she might be talking about, and I'm not familiar with the ban. So if they probably didn't ban it. If they did ban it, that probably would be preempted by federal law, and the United States laws, federal law, supreme law of the land under this supremacy clause of the U.S. Constitution. And so that might just be a simple case like that. It seems unlikely that's what they've done. But maybe they have, and maybe they'll just lose. But I have seen what states are trying to do is tinker with the advertising of lab meat. So they'll say they don't ban it, but they basically say you have to label it in weird ways that make it so unpalatable that you can't sell it. And the Institute for Justice actually had a case about that in maybe it was Florida, but it was in several states they'd done, I think, where they've had those laws struck down on the First Amendment, just to say, you're clearly just trying to regulate the content of my product labels in order to.
So the courts recognize the First Amendment as applying to advertising? I thought they did.
They do. I think it is true that they have a commercial speech doctrine that has a little more wiggle room, especially for product labeling.
Okay.
Especially if you're disclosing like what's in the product, they can force you to do that, and otherwise you might think that's compelled speech, but that's past muster. So they have a commercial speech doctrine that allows that, but I think it's overblown. I think people think that there's less protections for free speech in commerce than there actually is.
Okay, that's good to know.
It's not as bad as you think, but but there is a commercial speech doctrine that does give less scrutiny to regulations affecting the speech in commercial transactions. And mostly what they're concerned about is labeling and like disclosures of pricing and terms and things like that.
Yeah, I did think that I thought Florida had passed a law that said you cannot sell lab meat in Florida. So,
Yeah. Well, they'll probably lose that. Like, yeah, I guess that. I mean, it gets a little technical.
yeah,
You have to read the statute very carefully,
sure,
and
sure,
it gets down to,
exactly.
did Congress actually intend to preclude state regulation, or were they trying to carve out a part of it that states could regulate? And, it'll get down to the language of that statute.
Yep. Let's see. Rand asks, if the Supreme Court rules against the administration and the president refuses to abide by its decision, what, if anything, can be done to force compliance?
Yeah. I mean, that is the deepest question, right? There is just a reality of part of the Constitution is it sets up three branches of government, and they are in some broad sense co-equal. They have checks and balances. And if one is just refusing, the recourse really is the electorate at some point. And what you would hope is that multiple branches would have the back of the other, in the sense that Congress has tremendous power to restrain the executive through the power of the purse, or appointments. I mean, they just let agencies go dormant, or they refuse to allow anybody to be appointed. There are a lot of things they could do to put so much pressure that then it's a palpable crisis. And it's like, okay, this guy has to go in the next election. But, I don't want to be cavalier about that. There are not a lot of situations in which you get to loggerheads like that, but it is part of the tripartite system that we have, that at some level, it's up to the people to vote people in or out. And
Yep.
one branch can cause a crisis for the other. But if the people shrug at that, there's not much you can do. And, in some sense, uh, I don't want to normalize everything that Trump is doing, or make it sound like I'm excusing any of it. But I also just try to put things in historical context when I'm working day to day, and that people forget very quickly that, in the late 60s, the early 70s, there was an act of political violence in the United States every single day.
Yep.
Thousands assaults, bombings, murders.
Yep.
That's a crisis. And yet, things were a lot better 6 years later, and it was part of what propelled, say, the swing to the right, that then kind of gave us another 40 years of relative prosperity and peace. Or if you go back, to what FDR was doing, Korematsu is him, the internment of Japanese Americans.
Mhm.
Yes, the Abrego Garcia case is really outrageous, but compared to, so you would hope we would learn something and we would never do that again. But it's not like this hasn't happened and then the ship has been righted in some sense, or even the mania around immigration today. Yeah, there were periods in American history where immigration was open, and I wish personally we had a lot more of that. But we also had a Chinese Exclusion Act, and
Mhm.
it was at least as bad, worse in many respects. It was worse in many respects because it was seeded through the whole civil society, where it was segregation and, yeah, I mean, the democracy works through these things, and you hope that the Constitution is what stands. And I think that's in part why our current Supreme Court is like, it's much more important for us to right the ship with respect to the separation of powers and the checks and balances between uh, the branches, than to focus on writing every single individual case.
Mhm.
Eh, because I think they just have a faith that if you have Madison's system back in place, the Republic can stand through long periods of wild action. And, I mean, you can go on and on. It just like, Jackson and the Trail
Yeah.
of Tears, or things like that. I mean, the inhumanity of so many episodes in American history. We had thousands of lynchings in the South for,
Mhm.
for
Oh,
50 years that were
oh,
essentially uncorrected by the courts.
yep.
So it's not to excuse any of that. It's just to say, um, you could have a crisis here, and also, um, you could correct it.
Mhm. I mean, I worry about Congress because,
Yeah.
to correct it and for the courts to give back kind of that responsibility to Congress has to be willing to pick it up and actually do something with it. And as you said, since Reagan, it seems like, every term it's less.
Yeah.
It's more tribal, less thinking about its actual constitutional role and taking responsibility for it.
I mean, there's an intellectual division of labor here. That's why I try to stay focused on the law
Yep.
when I'm thinking, because what I'm trying to do is create space for people like you or ARI to do the
Sure.
more fundamental work that's required to change the culture. Because in very long periods of time, you can't really get beyond the cultural trend.
Yep.
You could. On the other hand, part of my optimism about all this, and part of the thing that fuels me waking up to do this work every day is, uh, I said earlier, you can't just like trick people like with Doge into reform or changing the whole legal system. But there are points of high leverage. And when I look at, for instance, uh, why did the administrative state just grow and grow and grow and grow? Like some of that is ideas, of course, but some of it is that during the New Deal, they captured institutions in a certain way, and certain precedents were established that were very hard to reverse. And so that even though you had continuous attempts to sort of swing back, they never took. Just the administrative state kept rolling on. You could, in fact, do that in reverse. If you have over the next decade, for instance, a restoration of the separation of powers, where Congress is sort of required to take more responsibility, the executive is restrained in what it can do in various areas in terms of regulation. Judges reclaim their authority to interpret statutes according to their true meaning and not defer to reasonable interpretations, so-called reasonable interpretations by the administrative state. You could go in reverse. You could establish a series of precedents that could buy you 70 years in the other direction, that creates the space that you and other intellectuals need to then make the cultural case that could rescue the country in the long term. So I have a lot of optimism that it's not so much a trick. It's just institutions matter, and there are linchpins of institutions. Then once you get those linchpins in place, there's kind of the institution can swing in one direction or the other for decades and decades and decades with relative stability.
To what extent do you think this is all made possible by the Chevron decision from last?
Yeah, that's exactly one of those linchpins, right? So once you get the Loper-Bright decision that reverses Chevron, you've now empowered judges to say, actually, I have a responsibility to judge the meaning of these statutes. And some judges will get it right and some will get it wrong. But what they won't do is say, well, whatever the executive branch's cronies or lackeys or hacks say in the administrative agencies, we're just going to let them do what they've decided is right, which is what's been happening for 50 years.
Mm-hmm.
And so that's exactly one of those linchpins. Like, well, okay, if we've got judges who care about separation of powers, judges who care about individual rights, who understand those concepts, I guess is better than care. You could have decades and decades and decades of a stable or even shrinking administrative state as opposed to one that's growing to a crisis proportion.
Adam asks, the U.S. forces citizens abroad to pay U.S. taxes. Can a future MAGA Congress forbid individuals from getting mRNA vaccines even abroad? If RFK forbids them here, given that Obamacare are justified as tax laws, Obamacare is not. Yeah,
I don't know. I mean, I get the point they're saying is just like how much power could MAGA related people exercise, and how hard would it be to sort of escape them? And yeah, I mean, it's very indirect, right? There are levers, right? They could just say, if you want to, you need to comply with tax laws, and maybe you need to comply with some kind of health laws if you're traveling back and forth between the United States or something. But it's all pretty indirect. And by that point, I don't know, have dual citizenship somewhere else. If that's the level of concern, it's hard to speculate about it.
Yep. Nature Observer says, is there a case for court to disbar all the lawyers who caved in the Trump blackmail?
Well, it would have to be a case before the judge, right? So this is the thing about judges have power to decide things in front of them, and they have power to enforce the rules and decorum inside their courtrooms. And so what I do imagine could happen, and maybe it will happen by the time this is all over, is you get some of these lawyers who are taking really extreme positions or the president is saying, if you don't, you're all fired if you don't represent this position in court, if they think it's implausible, or they're just hiding the ball from judges. The judges allowing discovery, and the judges are instructing people in the administration not to cooperate, or shielding them from cooperation. You could get judges who could say, look, you're going to get sanctioned. At some point, the sanction could get to disbarment if essentially the judges are saying, you may be representing the United States of America, but you are no longer trusted in this court because of your behavior. And that could lead to a disbarment. And, I would want to be careful about that. I think the other side was quick to do that around the January 6th stuff. John Eastman, I don't know if he's been disbarred or if he's just being threatened with disbarment right now, but he may have been disbarred in California.
Yeah.
And it's one thing if you're in court lying to a judge or instructing your client to not comply with court orders. I think you get disbarred from that. And I hope judges would disbar people from that. It's another thing if you're taking kind of radical positions to push the law in one direction or the other. I think it's pretty dangerous to start disbarring people from there. And I'm thinking myself foremost, like most of the positions that,
Sure.
Many of the positions I've taken at PLF are going against precedent for 50 years. But I'm saying, yeah, but the problem is that precedent is a real constitutional mess.
I think he's asking about, I think he's asking about the law firms that cut deals with Trump in order to avoid that executive order.
Yeah.
No,
I don't. I don't think
He's gonna
that's any kind of remedy.
Yeah.
They're not going to disbar it. What they can, you probably saw just Judge Howell, who's the DC District Court judge who ruled against in the Perkins Coie case. She really has a lot of language in there shaming those people, and I think that's what you can do. And some of those firms, I understand. One of the smaller firms, Sussman, I'm not sure which one, but I just read in the Wall Street Journal, there's an article about how many of their lawyers are leaving. And
clients might leave.
Yeah. You saw Microsoft, in fact, I saw, I can't imagine it's anything but deliberate. They made a decision to shift a lot of their business to Perkins Coie.
Okay.
And, so it's interesting. I don't know what interest or desire they had to kind of put themselves out there in that way, but it was quite public. So they clearly were trying to make a point with it.
It was pretty outrageous of Trump, right? This is not, have you ever seen anything like it?
No, I've never seen anything like it. And I think that's the places in which, but he's losing. He's 4 for 4, right? He got sued by 4 of the firms and he's losing. So it's like, yes, it's outrageous. We should call that out as outrageous, but let's handle it in the court.
But the legal system is still working.
Yeah, the system is still working in that sense. And, but I understand why people are alarmed. It is totally authoritarian in its tone and its effect. It's extrajudicial punishment, right? And, it's kind of clever in the way they're trying to do it. And they're saying, well, yeah, but some of these firms are violating civil rights laws and you're on sound legal footing to go after firms, but go after them in court. Why are you doing it through sort of this extrajudicial punishment? And I think the courts are going to hammer him on that.
So Lyron is asking, I don't know if you know this, he's asking, is Bukele moving fast to establish rule of law in El Salvador after a period of gang violence? Does he have a plan to improve due process as violence decreases?
I just don't know. I don't know what his ultimate aims there are. If you had asked me 2 years ago, I didn't know anything about him. I would have said, well, maybe, the country does seem like it's coming apart. And I would imagine if you're in a smaller country without tremendous resources, you might be doing things that we would find unacceptable because the country's on the brink of some kind of civil war or something. I don't even know if that's true, but it seemed like that might have been true a few years ago. But I'm, to the extent that I watch the news and him, he just seems like a, wannabe dictator guy. So I don't know.
Yeah, I initially kind of gave him the benefit of the doubt on that and basically said, when you've got that level of murder rate in the streets and you don't have the resources, something drastic. And if you do it and then you correct towards the rule of law, then maybe it's acceptable. But I see no evidence. Indeed, there's plenty of evidence to suggest he's just an authoritarian thug.
Yeah. Way outside of my knowledge, but I would be skeptical.
He was going after he picked up on Elizabeth Warren's idea that inflation is caused by grocery stores, and he was threatening the grocery stores in El Salvador that he'd treat them like the gang members if they raise prices.
Yeah.
So, you know.
Yeah.
Let's see. Thoughts on this is from Supikask. Thoughts on substantive rights, substantive due process.
Yeah, substantive due process is the idea that sometimes we have a 14th Amendment, Fifth Amendment, 14th Amendment both have a due process clause. The idea you can't be deprived of liberty or property without due process of law, and that has a very ancient roots. There are probably roots in Roman law. There's certainly deep roots in English law, and our due process clause was very much based on and imported a lot of the context of the English precedent on that. And in more modern era, conservatives will sometimes say, well, it says right there in the language, due process of law. It's just about process. And as long as you're getting the process that a statute requires, the government's on sound footing. The idea of substantive due process was like, no, actually, it's not just about the means by which the law is enforced. There are ends that are prohibited. There are substantive ends that are prohibited by the due process clause. Because if you look at the history of that, it was intended to stop the king, for instance, from doing certain kinds of things by any process. You know, he couldn't just deprive you of property at all if it were for certain purposes. So that's the idea that the due process clause protects substantive rights, not just whether you get process and being deprived of those rights. There are some things that the government just can't do. It's beyond the power of the government to do. Conservatives don't like that. You know, there's a rich academic literature on this, and you know, you can go around and around. My short take is they don't like it. Conservatives were all in favor of substantive due process to protect economic liberty in the 1890s through 1920s, and they all turned on a dime against substantive due process. Or at least the majority of conservatives turned on a dime when Roe v. Wade came down, because it was essentially a substantive due process case to say the government can't actually regulate something that invades your body in that way, your privacy in that way. And so they all said, substantive due process is a problem. It was the same time that most conservative judges favored judicial restraint and deference to legislatures and became critics of Lochner as the primary economic liberty case, which was also a substantive due process case. Yeah. So I think it's all bound up with sort of the social ends of the conservative movement, why substantive process is on the outs. But at this point, the current judiciary, the Supreme Court of the United States, is very skeptical of substantive process. And this is why you have this thing of text, history, and tradition. Maybe you heard that phrase coming from Alito and Thomas and Coney Barrett to some degree. They have different versions of it. And the idea is, well, no, some ends of the government are prohibited by the due process clause, but we have to root those prohibited ends in something that the ratifiers of the 14th Amendment would have understood as being prohibited by the due process clause. And so if we have a long tradition of prohibiting that, yeah, it's prohibited. But if we don't, then it just sounds like judicial subjectivism to us, judges picking and choosing what rights they want to say are off limits to the government. That's not constitutional enough. So anyway, that's a long, complicated answer. But in my view, I'm a fan of substantive due process. My constitutional law professor, a man by the name of Bernard Segan, wrote a book, Economic Liberties in the Constitution. He was a big fan of substantive process, thought it was totally legitimate as a doctrine, had great roots in history. So I agree with him entirely, but it's on the outs from conservatives. And the reality is, unless you can root something in the history or tradition of the country as being protected by the due process clause, you're not going to get it through this current Supreme Court. So it's not a fertile avenue for sort of the protection of rights that aren't already well recognized.
All right, Subikask also asks, what do you base your legal interpretations on?
I don't know how to answer that. Like I read the Constitution through the lens of the Declaration. I think it has a moral and natural rights context that should give rise to a kind of presumption of liberty. Whenever you're looking at something, the question is, yeah, the government might have legitimate purposes and ends, that some things it does that are in the Constitution I might not even agree with, but they're in the Constitution, so the government, can do them. That's the charter of our country. But when you're looking at those powers, you want to interpret them in a way that achieves the government's constitutional objectives in a way that is least violative of individual rights and liberty. And I think that comes out of the Declaration as the whole purpose of the country, or the polity that we've established, is to secure these rights. So that's a kind of an answer. I try to look at the Constitution through the lens of the Declaration, and that gives you, I think, a natural rights framing for most of what we're doing.
Do you think there's anybody on the Supreme Court who looks at it that way?
Yeah, I think they do, but they're skeptical of natural rights put that way. They might have a natural rights perspective themselves, like I think Justice Gorsuch is a natural rights kind of guy, but they don't think that that's within their purview in a role of a judge. And this is a deep argument, which is like, why don't they think that? It's so philosophical. There's a kind of the fact value dichotomy, or the is-ought gap. Like they say, yeah, I have my views, but my office as a judge is established by the Constitution. And I can't say that my understanding, natural rights perspective, though it may be, is a better understanding of these words than either the ratifiers of the 14th Amendment, or the ratifiers, the founders of the Constitution, or the democratic republic that is now around me and thinks those words should mean something different. So they have a real problem saying, I have authority as part of my judicial office under Article 3 to impose a natural rights perspective. That's the way they think of it, as imposing a natural rights perspective, as against doing their best to understand the meaning of the words as likely understood by the people who wrote those words, whether it's Congress or the founders.
Could the Constitution have included something that made it more explicit, connecting it to the Declaration, let's say?
I mean, it included a Ninth Amendment, which I do think it says, the Bill of Rights was not meant to prejudice all the other rights that you have, which is like a wide open, very natural rights kind of way of thinking about the world. And it's been disregarded. And I think it's been disregarded because of that discomfort around the is-ought gap. Like they're like, boy, that gets judges right into the question of like, what are values and what are rights and what are the limits of the police power? We don't want to do that. And so a lot of the originalism movement, so to speak, the idea of interpreting the Constitution according to its original public meaning, the words according to their original public meaning, is to divorce themselves from making value choices to making evaluations about historical questions, because they're on solid footing making historical judgments. They don't like value judgments.
Right. Ayala asks, what do you think will come of Harvard's lawsuit against Trump administration? Do you see broader implications for academic freedom or the role of government in higher education?
Yeah. I mean, I think that's, well, yeah, it can go a lot of ways. So first of all, what they're doing is, removing a lot of funding, grants. A lot of these are like grants for studies and medical stuff. And it's just the whole range of things. They're just pulling all the money that they can from Harvard. So there are like several layers of questions here. So on the one hand, can they do some of that? I don't know. Some of these things are just like contracts. You can't just rescind contracts unilaterally, right? So they might get dinged on that, and so they might get stopped from doing some of that. Some of it is retaliation and viewpoint discrimination. The courts are not going to allow that to happen. They're not going to allow funds to get removed because people in the administration don't like the viewpoint of the people who are getting the money. So like the first cut of this is that they could lose a lot of that. The administration could lose these cases. On the other hand, they're on pretty sound footing to say you can't get grants, like new ones, if you're violating civil rights laws. Those are legitimate conditions of getting money from the federal government. You can't violate Title VI of the Civil Rights Act, 1964 Civil Rights Act. And their argument is a lot of the anti-Semitism that they see at Harvard, some of the policies with respect to their hiring and DEI related things do violate those laws. And to the extent that they try to do it by unilateral executive action, they're going to have trouble. To the extent that they get the Department of Justice to sue Harvard to prove out that they're violating civil rights laws, they can get it to stick. So it's like, hopefully there's some people there who say there's a strategy to this and let's do it the right way. That might have, from the perspective of objectivists or people who are more in favor of limited government, have a good effect in that the federal government could distribute a lot less money to higher education. I think that's probably all to the good. The way they're trying to do it, I think they're going to have a real problem with the courts, because it sure does look like First Amendment violation. It sure does look like they're just rescinding contracts in ways that are not allowed by the APA or other statutes.
And doing it so selectively on particular institutions.
So that's the viewpoint discrimination. Yeah, the court's going to say why this one and not that one, and it's going to be because we don't like the viewpoint that you have. The other question, though, that maybe was implied there is, what I would hope is that the government would just be less involved in higher education as a political matter. But
Yep.
To the extent that they rescind all these contracts, they might just start giving contracts out to people they like, and they probably have a lot more power to do that. If you're taking something away from somebody based on their viewpoint, it becomes pretty easy to prove a First Amendment violation. If you're giving money, there could be so many reasons why you're giving money, even if behind the scenes some of it is we just like these people better. They could probably get away with that.
Subkaski, let's see. Conservatives claim to believe in natural rights and liberties, but their legal scholars and justices have led the charge in narrowing the Constitution's protection and recognition of them. Why? I think this goes to your previous answer.
I do think that is pretty philosophical. I think that, and this is, a structural issue, like unaccounted for effect of the Civil War, the Reconstruction Amendments, the 13th, 14th, 15th Amendments. Like, before the 14th Amendment, if you're a federal judge, your job is pretty easy. You have you may have natural rights perspective, but you also have a legal doctrine that the federal government is one of limited enumerated powers, and my role is to keep the federal government within its lane. So use the contract clause or some other things to stop them from doing things that might be over-regulating. And then you leave everything else to states and state courts. And state courts were pretty wild. Some had very explicitly like natural rights doctrines that maybe did admit a lot of judicial subjectivism, but they were limited because it was one state by state, and so they had this a little bit of Wild West in the way that courts could interpret their own constitutions, and there wasn't a lot of supervision by the federal government. The 14th Amendment changes the whole structure of the country, and now you're a federal judge, and the federal government is now interposing itself between states and their own citizens to decide whether or not those states are violating the rights of their citizens. And by what standard? Well, by the standard of the 14th Amendment. So are they violating the Equal Protection of the Law Clause? Are they violating the Due Process Clause? Are they depriving people of privileges or immunities under the 14th Amendment? These are very broad. Broad is not the right word. Conceptually, what does due process of law mean? To what extent does it mean process versus substantive due process? What are the privileges of immunity? There's no list of them. What does equal protection of the laws mean if like the South is saying, well, we're actually treating blacks and whites equally, we're segregating them both to their respective places. Is that equal protection or not? For a while, yes, ultimately, no. The federal judges are faced in this very uncomfortable position of saying, I can have anyone in the country come to a federal court and say, my state is violating my rights, and I have some right that's not recognized by state law. How does a judge avoid some pretty deep values questions? And this is the era of the country too, 1890s, the progressive movement, the pragmatism, like what's going on philosophically, like educated people are becoming more and more uncomfortable with either faith or religion or a natural rights perspective, giving them some certainty about what values are absolute. And so it becomes very dicey. And so they start retreating, they start narrowing the scope of protection, because what are they going to do? They say, well, who am I, one judge, to say my values mean more than the electorate of your state if they've given you this right? And so they start creating all kinds of categories, and they start looking to the Bill of Rights as well. If it's in the Bill of Rights, we know we're on solid footing. And that's why you sort of move away from that natural rights perspective, and you get kind of legal positivists who are saying, well, if it's in the Constitution, I know I can enforce it. If it's not, yeah, I'll hear your argument. But you got to get me comfortable that there's a reason for me to go that way. And that's why you have this text, history, and tradition. It's like, well, if it's deep in our traditions, okay, like I don't feel like I'm just using the power of my office to impose my values or yours on the electorate. There's a reason that goes beyond just the current election cycle for me to impose this.
Yep. Let's see. Jacob asks, what influential case was not taken up by the court that you think they should have ruled upon? What would have been the effect of a ruling?
Well, that's putting on the spot. I mean, they I mean, it's more cases that they've taken up and just decided wrongly. I mean, 15 years ago or so, they had an opportunity to overturn Wickard v. Filburn, which would have really put more teeth into the Commerce Clause, and they didn't do that. And they finally took Loper Bright, but people asked them to do that for 10 years earlier, so there was a time. So uh, what we needed was something like Loper Bright, and now we need 10 more Loper Brights, which is like agency by agency. We have to have regulation after regulation after regulation reinterpreted by judges away from the very expansive interpretations of the administrative agencies. And that's what it's going to take. That's partly why I'm so motivated by PLF's work. It's like we can take dozens of these cases every year, and that's what you have to do. You now got where the courts have given us some room to reinterpret things in a direction that's favorable to freedom. We need to actually take those cases up and litigate them all the way through.
What happened to the Kelo case that went back to the Supreme Court? The eminent domain?
It was denied. Yeah, they didn't take it up.
They didn't
The last term, there was IJ had the Institute for Justice that litigated Kelo
Yep.
had another case that they petitioned, and it got relisted several times, which means that the courts were really thinking seriously about it, or the Supreme Court was really thinking seriously about it. And you just don't know, right, why they don't take up a case exactly. So it didn't get taken up. But that will be at some point.
They will take it.
There's probably a majority against it now, and the academic literature and everybody else is like, they made a mistake and they know it. So
Okay.
it'll get taken up at some point. I have to wrap up pretty quickly because I know my daughter is coming back from.
Okay. So let's do this. Any thoughts on railroad law? I know people in business seem very statist arbitrary, specifically land ownership and liability for injuries.
Sorry, I'm just writing to my
Okay.
nanny here. So I heard a railroad law. Can you repeat that? Because
Just thoughts on railroad law and its impact. So
No, I mean, this is a way in which law, maybe there's a story there, maybe this is what the person is getting at in the 19th century, where sometimes law is just it has to shift to make room for new things. Maybe we'll see this in AI or who knows what. But what happened with railroads in the 19th century is tort law for, all of England and the beginning of our country was you were basically strictly liable for any injury on somebody. And when railroads started killing people, just like running people over, running into things, damaging property, but they were such an obvious social good, right?
yeah.
So you had to make room for them in the law, and they basically couldn't operate under a strict liability policy, or at least not grow the way they did. And so tort law switched to the negligence standard, mostly because of
Oh, I didn't know that.
railroads, because they said, well, look, if you're, both parties have a responsibility to sort of take account of the situation and act reasonably. And if the railroad is negligent in injuring you, fine. But if you, let your cattle graze near a railroad and some get hit, you're not
Yeah.
getting paid for them. And that was essentially the negligence standard arose out of the railroad. So maybe so tort law changes over time as a result of social conditions changing and new technologies. And I don't have any thoughts about that other than I think that was good. But they may be talking about something else. There's all the landlord grants where the federal government gave tons of land to the railroads, and it was all misused, and it was all cronyism, and
That was cool.
that was kind of a disaster. Yeah.
Michael says, hi, Larry, big fan of your work. Thoughts on the constitutionality of the First Amendment auditors?
I don't know what that is.
I don't know what that is either. All right. Wyatt asks, do you agree with the fact that Trump's lawyers were disbarred post 2020?
Uh,
And I don't know if that relates
yeah, I think that probably reflects on the John Eastman thing.
Eastman.
No, I don't think that was the right move. I mean, I guess there are two things here. And I'm reluctant to speak too much on the Eastman case because I know him. I haven't talked to him in many years, but we taught a class together at Chapman University when I was a professor there, and he was a professor there.
Yeah. I got to know him a little bit during that period.
So I know his views inside out. So, the legal advice he gave to the president, I think you could say is irresponsible. I don't think that someone should be disbarred for taking kind of a radical position of the law and offering it. What the president does with that is something else. On the other hand, there is just a question of like, do you want lawyers who have like good moral judgment? And there's a long tradition of people being disbarred for, bad moral behavior. I don't think that's necessarily wrong. I mean, courts have to trust these people. There's some level of venality that you'd say, well, you probably shouldn't be an officer of the court anymore. And so, if you separate the legal advice he gave, or some of the other lawyers that gave it, wasn't just Eastman. Maybe I can speak to that other woman whose name I forget now.
Sidney Powell.
Yeah, who took a
Sidney
lot
Powell.
of crazy positions. Like, yeah, I don't have a problem with her being disbarred because she was in court saying things
She
that
was in court, yeah.
were far beyond what she knew. Sometimes she would just make representations when it turned out she actually did nothing to prepare. She was just making stuff up on the fly. You can't do that in court.
Yeah.
I mean, the whole point is to render justice. So I don't have a problem there. Or even, some of the others who were like, took part, I think John Eastman did this, took part like on the stage at the January 6 rallies. You might say, well, the disbarment would have nothing to do with the legal advice he gave.
Yep.
And sort of his First Amendment rights to offer that advice or his professional judgment. But maybe he was just doing things in the political atmosphere that are unbecoming of a lawyer. I don't know enough to know what the precise reasons why he was subject to disbarment were. I think it was his legal advice, though, and I think that's very dangerous. I don't think we should go in that direction. But if you're in court making false representations, yeah, you should get disbarred.
I think Giuliani was disbarred as well.
Yeah, yeah, absolutely. I mean, I didn't follow this
He
that
did more
closely,
than give
but if you look
advice.
at the things in the defamation case he had, he was just making stuff up and he knew it was wrong. So there has to be a penalty for that. And I think if you're a professional who's representing things before a court, you get disbarred if you're lying to a court.
The big one. How confident are you in the court's ability to stop a fascist dictatorship from arising?
Pretty confident, actually. Pretty confident. Yeah.
Michael, is there a constitutional crisis? If there's a constitutional crisis, will the military turn on Trump to uphold the Constitution? There is no role for the military in the Constitution, is there?
Yeah, I have no idea. Well, no, I mean, there's way outside of my expertise, so I really shouldn't speak to it. But there are, I mean, you can order in the National Guard for various things, and presidents have, right? Well, I mean, they were
Could
ordered
somebody
in.
order it against the president? I mean, who would have that authority?
Yeah, right. I mean, you'd have to basically get, the cabinet saying he's unfit or something and removing him from office or superseding him.
Yeah.
Because
other countries have constitutions.
Yeah.
Other countries have constitutions that give the military a role in all this, but our Constitution clearly does not.
No, so I don't have any advice on that, except like our military is completely in civilian control in the United States under our Constitution. And so what you would imagine and what you'd hope would happen is he does something weird, he orders something weird, and people just all resign, right? Yep. And you go, and you've had that kind of situation like under Nixon, you'd order the Department of Justice to do things, and one person after another would resign until you get to the bottom of the barrel, and you're like, well, we really can't do this because we don't have the people in the office who.
A lot of people resigned after January 6th.
Yeah.
We got close to that after January 6th, but
yeah.
All right, we got how many questions? 6 questions.
Okay. You're going to do a rapid fire.
Oh, 5 actually, just 5. Okay. What do you think of Trump's executive order regarding trans? And I guess it was in the military, or were there broader executive orders as well regarding the trans issue?
I don't think I know them. He's gotten 320 executive orders or something. I claim to have read maybe 100 of them. They're sort of so I don't think I should comment because I don't know. I did see that the Supreme Court
refused to.
Didn't get involved in the current stay of one. Yeah.
So it's going back.
But all that means is they're going to take it up.
The lower courts.
Yeah, they're going to take it up in due time. Yeah.
So this is Evitech. He says, it was great hearing the positives about the shrinking of the administration. I don't hear that much. Where do you learn about such things?
I mean, some of it I'm just reading the executive orders and what it's actually doing. And then, I have the benefit of overseeing a lot of cases that are suing the federal government. So sometimes it's in court where the lawyers are coming in and disclaiming positions that they previously took and saying, actually, because of a change in policy, we're no longer defending this, or
Hmm.
we're reversing our position on that, or something like that. So I'm seeing it in action in some cases. And the most interesting thing that I got, probably never see again in my lifetime, certainly never have seen in my lifetime, is I got an email, like directly to my email box, from some person that I don't know at the OPM, whatever, Office of, I don't know, something in management,
Personnel and management and
personnel management. It sort of runs a lot of these
budget. Yeah, they do all
budget
the
things. And so, anyway, somebody in that office just wrote me an email to say, I wanted to advise you about this particular executive order, and make sure you had seen it. And so I don't know this person. They knew to send it to me, so they know I have certain position at PLF,
Yeah.
and they knew it was on exactly a topic involving the Endangered Species Act that had reversed positions that had basically been the EPA's position for decades,
Yep.
and which we've litigated in the past. So it's like, that's why I say, like, they have people who know what they're doing. Like they know who would be interested in this order and who could sort of help us implement this order in some sense. Like who's going to go to court in the next case and say, hey, you used to take this position, but you have to take this position now because of this executive order. So it's fascinating.
Good.
Yeah.
What's your view of originalism? I think Chemerinsky makes a pretty good case against it.
I don't think of myself as an originalist. I think concepts have meaning that are independent of what the people who wrote them down or thought them up do. On the other hand, the rule of law has to have a lot of stability to it. And I don't think you can ignore, as part of your analysis of a text, what the people who drafted it thought they were saying. So, original public meaning, to my view, clearly has a role in understanding the Constitution, understanding a statute. I don't think it can be determinative in all cases. And I think that's where I depart from originalists.
Let's see. Was Trump versus United States 2024 regarding presidential immunity decided properly?
In broad strokes, I think yes. And I say in broad strokes because I've read the decision 3 or 4 times. I don't think I know entirely what it means, what the implications are. I really think it leaves a lot to be decided in the future.
Yeah.
But I think there has got to be something correct in that. And first, and also this, by the way, comes from a conversation I had with Onkar and Ben one time, who I think very well about that decision. I understand why it's called presidential immunity. That's kind of the traditional way of thinking about exempting an officer from certain kinds of laws or suits in legal tradition. So it has that word immunity, but I think people misunderstand what it means. And really what the decision said is not the president can do no wrong or the president can't be sued. It's that under the Constitution, Congress doesn't have authority to write a law that binds the executive branch in its core powers. Like things that are exclusively assigned to the Article 2 branch can't be regulated by criminal laws by Article 1, Congress.
Mm-hmm.
And in that sense, it's really a case about the separation of powers more than so-called immunity. But the effect of it means you actually can't sue the president for certain of his actions. But what's left to be desired in that decision is, well, which actions? Even something as simple as, I don't think it's clear in that decision in the end whether he can be sued and held criminally liable for bribery. And if it affects a court, like can he take a bribe for issuing a pardon?
Yeah.
It's not really clear. I mean, maybe that one instance is clear because it came up during the oral argument. And it sounds like, yeah, he can be sued for that, but he can get pretty close. And I think that's what you're seeing him taking advantage of with like the meme coin stuff. And,
It's going to be interesting if anybody sues around that as a bribe, but who would prosecute
but that's different. It might be an emoluments clause case. It might, and that's something the court hasn't adjudicated in hundreds of years, 200 years. So we'll see. But I think in broad strokes, the theme of the case is correct. You can't have the president being sued during his term for actions that are assigned to him to be responsible for by Article 2 of the Constitution.
Yep.
That would create instant banana republic, I think, in a political atmosphere that got really tribal.
Yep.
But how far that goes, which actions, what are the other things that can happen to the president to check his bad behavior? Yeah. It's all left. It's all
if I
left.
remember right, Barrett had a really interesting concurring opinion with that
Yeah.
one.
Yeah.
That was try to get to the nuances of some of these things.
Yeah.
Um,
I think
Last question. What can I do to help legal organizations? This is a perfect question. What can I do to help legal organizations fight for the rights as a volunteer? Which organizations would you recommend?
I mean, certainly I recommend Pacific Legal Foundation. And what can you do as a volunteer? I mean, we like support, right? So people share things. We want to get more eyeballs to our work, to get more clients, to get more donors. So to the extent that you spread the work on social media, to the extent that you tell people about what we're doing uh, in an informed way, you look at our website, Pacific Legal Foundation, pacificlegal.org, uh, become familiar with the cases. But, the hardest thing is finding cases to some degree. Like there's so many cases that don't quite have the right facts. So to the extent that people are able to share information about what we're doing and why, it leads us to interesting conversations with people who have the kinds of problems that we can solve and lead to good precedent. So that's that. And then, of course, there's always supporting us with money, right? We appreciate we survive on contributions. In terms of organizations, I mean, I love my own organization, obviously, but there are a lot of good organizations out there. I mean, IJ does great work, and I used to work there. I'm certainly a supporter of them. There are, at this point, I don't know, maybe 75, 80 organizations that are broadly considering themselves as part of the conservative, libertarian legal movement. Some are good, some are not. I mean, I would say look for the ones that are doing the things that you care about, because some of them are more religious liberty, some are more free speech. I do like FIRE, freedom, individual rights and expression. So they're certainly good. There are organizations that do really mixed work that I'm reluctant to recommend. I like a lot of what the ACLU does when it comes to free speech. Sometimes, they're taking much of the mantle for immigration work right now in some of these more radical cases or harder cases. So, good for them. On the other hand, on the same free speech side, they came in against us in a case in which we were arguing a free speech claim on behalf of a business that was being threatened by, a prosecution for allegedly speech that might disincline people to seek out loans in minority neighborhoods. So it's just like a DEI or it was just a racially charged prosecution by the Biden administration, and they came in against us on that case. And it's like, why? We're clearly defending the free speech rights of somebody who didn't do anything wrong and should have First Amendment protection. And I think they're just really confused. They're basically supporting anything that's on the progressive side, and if free speech aligns with that, they'll do it. If not, so anyway, that's not a recommendation. It's just say people might wonder, like, there are good organizations doing some good work that I really admire, and yet the organizations are being led in ways that align them with the progressive movement that I just don't. I'm no longer a supporter of them.
But it is pretty amazing how many kind of on the side, on the free market side, how many legal organizations there are today. I don't think that was true even 20 years ago.
No, I mean, and a lot of them are specialized. So, IJ and PLF are the largest of the organizations for size of lawyers, number of cases. We have the most case volume, I think, of any of the organizations out there. PLF does, but there are places like the New Civil Liberties Alliance doing great work, but it's exclusively about separation of powers. Or you get places like Beacon Center in Tennessee, where they're doing good work, but it's just in Tennessee, right? So it's like, but that's what I think. If somebody should look what their interests are, if they're really interested in supporting cases in their backyard, they should be supporting some of those smaller organizations that are doing good work.
All right, this has been great. Thanks, Larry. Really appreciate it. Thanks for your time. Thank you, guys. Thanks for all the support and the questions. And I will see you guys probably tomorrow. Bye, everybody. Bye, Larry.